So Vijay Lakshmi, who named
Yes.
you Vijay Lakshmi?
So my Nana ji gave this name to me.
Okay, what was the reason behind it? Any specific reason?
So when I asked him the reason behind naming this thing, he told me that there was one another girl by this name, and he was really fascinated by this particular name. So that's why he just gave it.
Okay, he just gave it. Why is there a lot of pendency in the judiciary? Can you suggest some reasons in pointers?
Yes. So first and foremost reason is the inadequate judicial capacity in our country.
Second,
So which so
second.
second Yes, sir. So second is low judge to population ratio in India. That is around 20 judges per million. So
Hmm,
which is far below that has been recommended by the Law Commission.
hmm.
Uh, and so third would be so the infrastructural bottlenecks which are being present. That is the lack of e-infrastructure in our courts. So that can also be cited, and along with some minor issues such as the adjournments or the legal delays which happens due to
Do
the
you also
ongoing.
blame the police ecosystem or the policing in India and the investigation in India to be a part of it, to be a part of the delay?
Certainly, sir. The police also forms the part of criminal justice system, and it all starts from the filing of the FIR. So
Hmm.
first delay in filing FIR, so second in charge sheet recording, and so third, even the police is overburdened due to the combined burden of investigation as well as the policing functions. So that is something which needs to be addressed.
So recently, Supreme Court has come down very sharply or very heavily on Ranbir Allahabadia. How would you play a defense lawyer? How will you defend? How would you defend him in the court? You know about the case, right?
Yes, sir. So my first point of defense would be under so Article 19 itself, that is the freedom of speech and expression.
Hmm.
And so second, even the Supreme Court has said that sanity has to be seen from a very higher threshold, wherein it corrupts the mind of the viewers rather than just taking it on the face value. So that would be my second point of defense.
Okay. Would you want to change your stance as a prosecution now?
Yes, sir. So, being a prosecution lawyer, I think first and foremost, I would say that there are reasonable restrictions which are being placed under Article 19 itself, that is public morality. So, although it is not defined, but the contemporary standards of the society should be taken into care. And so, second is that the self restraint should come from the people who are delivering any speech on the public platforms. So, that would be the second point.
Why was the recent website banned, which depicted the cartoons of the Honorable PM of India and Donald Trump? There was a recent cartoon banned. The website was banned.
Yes, sir. So, it was mainly done under the reasonable restriction only that when we are showing some relations with the foreign countries in bad light or derogatory perception of our honorable prime minister. So
Under
these,
which law was it banned? Are you aware of it?
yes, sir, it was under IT Act.
Section?
Uh, so section 67, perhaps.
Section 69.
Yes, sir,
And
60.
the clause used was friendly relations. So don't you
Yes.
think that that was a very, or the national interest or friendly relations is a very wider concept and it has to be narrowed down now, Vijay Lakshmi? It is more being used to stifle the freedom of expression. Don't you feel that? Hmm.
So there are certain provisions which have wide interpretations and are subjective to the judicial interpretations, such as the public policy and even the friendly relations. I believe if a more clarity can be brought forth, so it can balance between both the rights, that is, right to freedom of expression as well as our national interest.
Hmm. Any reforms would you suggest in the Lok Adalats?
Yes, sir. So first, I would talk about the thing that, so for instance, in National Lok Adalats, we have an annual calendar that is being put forth. So similar practices can be adopted in the lower level Lok Adalats, that is of state and district. So second would be, sir, more engagement of the public by the use of social media, wherein awareness can be provided to the people with respect to this alternate dispute mechanism.
Vijayalakshmi, what was the recent controversy related to the appointment of election commissioners of India?
Uh, so, as the union government has brought in the Chief Election Commissioners Appointment Act after the Supreme Court judgment, so in this particular act, the composition of the committee was changed, which was being prescribed by the Honorable Court. And so in the Chief Justice of India was being replaced by the Cabinet Minister. So it was creating a perception that it gives an upper hand to the ruling government itself.
So what would you have done if you were the in charge?
So in charge of the drafting committee of the legislature.
Yeah, drafting this law. Would you bring any changes, or if you were the CJI, would you strike down the amendments by the Parliament?
So although the law was passed by the legislative under the legislative competence of the Parliament, and only if it infringes upon the basic structure or some constitutional provisions, only then the law can be struck down. But sir, in a democracy, sir, I believe it works on perception of people as well. So for free and fair election, that should also be upheld. And if, sir, the people feel that bringing CGI in the composition can address this particular issue, so then the amendment can be made to the law.
So Vijayalakshmi, moving away from law, I make you India's ambassador to USA. Who would you have preferred to be the president in the national interest of India? Donald Trump or Kamala Harris?
Sir, I am not exactly aware of the policies which Kamala Harris has proposed during the presidential elections race. But sir, going by the present context only, so I think by far we had very cordial relation with the United States and the personal rapport which our Honorable Prime Minister has with Donald Trump. So there are certain issues such as the trade tariffs on which definitely we need to work upon. But apart from that, we are going forward, I think, in a right direction. For instance, the cooperation in the nuclear energy.
Is Haryana moving away from patriarchy, or is it increasing day by day?
So if we look at the past data and if we compare it with today, certainly there has been a lot of progress. So for instance, the sex ratio has improved substantially from 2014. And so second, even the people from the rural areas are sending their daughters to pursue whatever career choices they want to do, be it in sports, education, or any related field. And even so, the government is also very instrumental in bringing policy changes which can change the attitude of the people.
Recently, I read a report that the charm and the charisma and all the hype around Beti Bachao, Beti Padhao has been reduced again, and the scheme is fizzling out. Why is it so?
So certainly there was a dip of a certain percentage if we compare it with last few years. So it can be attributed to a number of factors. So first, when a scheme is launched as a fresh scheme, I think it comes with greater enthusiasm from the implementation agencies. So second would be, so I think this issue is not only limited to Haryana, but even the bordering states of Haryana also somehow contributes to this issue, wherein people go to the bordering states and they go for sex selection. So apart from that, sir, that also needs to, the coordination between state needs to be maintained.
What about the Jat reservation? Do you feel that Jat should be reserved?
So any affirmative action should be based on the historical as well as the present context, wherein that either they have been at a disadvantageous position
Hmm.
But sir, in Haryana, I do not feel that the Jat community have been discriminated, be it in terms of economic or social indicators.
Can you recall of any committee which has said this?
Sorry, sir, I'm unable to recall any committee
Okay.
name.
No worry. Who is the master of roster in India and why?
So it is the Chief Justice of India who assigns the particular cases to the respective benches of the Honorable Supreme Court.
But recently, Justice Chandrachud retired. He said that it is not in my hands to allocate any case particularly to any particular judge. Is that so?
Sir, I am unaware of the exact nitty-gritties of the allocation of the cases. But whatever I have heard, according to that, the CGI is the master of roster of cases.
Should CJI be the master or the collegium should be the master, or it should be done algorithmically as per whatever the computer assigns to bring in more impartial, more transparency and neutrality and objectivity of judges?
So certainly the technological intervention can limit the human biasness as well as any perceived thing which the judiciary is sometimes accused of. So that can certainly solve this issue. But so apart from that, I think human oversight that can be based on a broad-based committee that can oversee this thing. So combined of both these things can be a way forward.
Who is the higher judiciary in India accountable to? There is no judicial accountability as of now, I feel.
Uh, so the judiciary is accountable to the parliament when it comes to their accountabilities, are as in the parliament has power to impeach the judges if they do any act which is unconstitutional or misbehavior or so the grounds which are mentioned in the constitution.
No, the grounds are not these. You're wrong. What are the grounds? Violation of the constitution is not a ground for removing the judge of a Supreme Court or a High Court. The grounds are misbehavior and incapacity.
Incapacity.
हाँ
Yes,
जी.
sir.
अब आगे
Yes.
चलो.
Uh, So, sir, I think there is sufficient provision in the Constitution which provides for accountability. But, sir, despite that, there are certain issues. For instance, the opaqueness of the collegium or the judicial pendency.
Hmm.
So, these are some of the things which are not being taken care of. And for that, sir, I think a proper in-house mechanism can be evolved by the judiciary, wherein it can involve various stakeholders such as the Bar Council of India or broader committee rather than only the judicial fraternity in that.
Why were there conflicts between the lawyers and the policemen? In Delhi also we've seen that. In UP also we've seen that. Why is the lawyer community up in arms against the policemen? Do you lawyers have issues respecting the laws or wearing a seat belt or getting challaned if you are breaking the laws?
So I think no one is above the law, and every profession, be it judiciary or lawyers or police, everyone should follow that. And so, if this is the cause, then sir, I do not support this thing that any particular profession should be treated unequally or at a privilege.
What about judicial appointments? The NJAC Act was struck down, citing that independent judiciary is the basic feature of the Constitution of India, autonomy and independence of judiciary. And since then, the memoranda of procedure has also been very controversial. So, how do you see it? Who should appoint judges and where should the reforms come from? If not the parliament, then who?
So, given the fact that independence of judiciary is one of the basic structure of our constitution, and to preserve that, uh, so along with preserving this independence, we also need to ensure accountability. And so, for that, a reformed collegium would be something which would be in interest of all the parties. So that can include the judicial fraternity. Along with that, some members from the Bar Council of India can also be included. And so
Hmm.
government representatives should also be the member of the collegium.
So, who would you want to pick from the government in the collegium? Last time also we had the law minister in the selection committee. in 2014-15, if I recall nicely. And there were two other members which the government could appoint or nominate. So, but the judiciary did not agree. So this will again be struck down if there are any. And who will do it? Will the parliament again? Should the parliament again amend it? Or what should be the way forward? What do you think? What can be the solution?
So a consensus oriented approach can be taken wherein both judiciary as well as the parliament come together and discuss the basic issues which are being plaguing due to the opaqueness of the of the collegium. And so based on that, I think approach can be prescribed wherein a members from a broad-based committee can be formed.
So there are issues with the memoranda of procedure. Are you aware? VIJAYLAKSHMI, MOP, for appointing the judges.
So I have read about the MOP that it promotes that there should be inclusiveness in the judiciary and there should be a time
And
frame
there is
within
no,
which.
so this is not my question. My question is that there is a constant tussle between the executive as well as the judiciary when it comes to the MOP. Now, you were the best mediator. How would you mediate between them?
Sir, I'm not exactly aware of the tussles of the MOP.
Hmm.
But sir, if like going by the present context of appointment only,
Hmm.
uh, wherein judiciary appoints the judicial officers only. So, sir, in that case, so first and foremost, I would list out the issues which are being plaguing the judiciary due to this opaqueness.
Hmm.
And so second would be that I would put forth the argument that justice is not something which is to be done, but that should be seen to be done. And it is the duty of both the judiciary as well as the legislature to uphold this particular constitutional ethos. And so third, I would go for a stakeholder-based mechanism wherein sub-party, wherein the members from all the organs of the government can be a part of that committee and they can recommend. But sir, ultimately an upper hand can be provided to the judiciary to
Why
ensure
did
judicial.
India dehyphenate Israel and Palestine?
So the policy of dehyphenation is based on the strategic interest of India, wherein it does not side with one of the party, rather it deals with the nation based on its own interest. So, for instance, in Israel, we have defense agreements, and also that we have recognized the state of Israel. Apart from that, we have various other agreements in agriculture and like sectors.
Hmm.
And so, Israel being one of the major player in the Western Asia, that also makes it important for India. But so, on the other hand, even the Palestine, it is with respect to India's values that the right to self-determination is something that needs to be adhered to.
Hmm.
And so, due to that, India maintains ties with both the nations.
So what is this new upcoming Donald Trump and Palestine issue? Does he want Palestine or what? He wants to annex it. He wants to make it America's territory, just as Greenland, or what is he trying to do with Palestine? Donald Trump.
So, as per his statements, he want to rebuild Gaza by removing the people of Palestinians from there,
Hmm.
and they can take refuge from in other neighboring states.
Hmm.
So, I believe this is against the international law and the basic principle that is right to self-determination of the people. And
Hmm.
so more, it would also hamper the peace process which is being ongoing in the West Asia. And so third, it would fuel the refugee crisis and the displacement in the neighboring states, which are reluctant to take those people in.
Hmm. So what is an art?
So art is something wherein we can express ourselves in innovative manner, or we can so formulate something which which is not ordinary to oneself.
Okay, please elaborate. This definition of art I feel is unclear. You are an art journalist, right? Art journaling you practice.
Yes, sir.
I just wanted to know what is art. Okay, what is art when you practice journaling? What type of art do you inculcate in journaling?
So there are a number of things which I do. So for instance, so first is the doodling,
Hmm.
that is making caricatures and sketches in the journal.
Hmm.
So second is using some scrap papers and items which are of not use, such as the waste papers
Hmm.
or leaves or the petals. So that can be used to create a decorative item. For instance, any flower.
Hmm.
And so
Recently, there was a web series on Tihar jail, right?
yes, sir.
Have you seen that? Black Warrant.
So I have seen the trailer only. I am yet to
Okay.
watch that.
Okay, you are yet to watch it. So
Yeah.
please tell me, should the death penalty be abolished? It was all about jail reforms and death penalty. What do you say? Citing the, okay, I'll give you a background to my question that there is a lack of clarity in the doctrine. The doctrine is rarest of the rare, right? And there's a lack of coherence in the rarest of the rare doctrine. Some places we see that it is being used, some places we see that it is not being used. So, death penalty in that light, should there be a policy of the judiciary? Should there be a coherence guideline that whether or not you should completely abolish it or you should keep it with you? What should be the way forward?
So, although the ultimate aim of the prison is the reformation of the people, but so in cases wherein the person is beyond reformation or has become threat to the society in
Hmm.
such a manner that
Hmm.
it would entail huge cost and it goes against the principle of justice itself. So,
Hmm.
in that case, death penalty can be prescribed. For instance, in the rape cases or the gang rape or even in the terrorist matter. But sir, leaving this doctrine undefined, sir, it leaves a room for judicial subjective interpretations. So, which I think it goes against Article 21 itself. So, sir, a clear-cut site can be defined more clearly that what can constitute rarest of rare case, and sir, on what basis a person can be given death penalty. And so, even going a step further, even if a death penalty is not being given in appropriate time, what is the remedies available or what should be the way forward for that? Sir, a more clarification would uphold the idea of justice.
Hmm. Do you think that states need to relook their information policy, their RTI policy? There is a lot of pendency in the RTI as well, and the uh, commissioners are not being appointed, and PIOs are not, they are not willing to give information. There are more number of rejections we are seeing. So, how do you see it? Let's talk about the RTI reforms.
So, denial of information goes against the very objective of
Mhm.
to provide information. So, apart from that you mentioned.
Okay, Vijay
So, sir,
Lakshmi,
I think the
the whole
step.
answer, you'll have to repeat your answer because सारा का सारा आपका इंटरनेट कट गया था शायद, है ना? तो आप एक बार रिपीट करो इस आंसर को. We are talking about the RTI reforms. Hmm.
Yes, sir. Yes, sir. So I was saying that there are major challenges to RTI Act. So one is the non-disclosure by the PIO. Second is the half or incomplete information, and the third is the vacancies.
Hmm.
So to address this, the first and foremost, I think the utilization of Section 4, that is the suo motu disclosure by the PIOs, that needs to be ensured. And sir, for that, the government can take proactive steps
Hmm.
wherein the PIOs who are habitual in declining the information or who are not showing the information, so a disciplinary action can be taken against them.
Hmm.
And so the ones who are doing it regularly and incentivization can be provided to those PIOs. So
Hmm.
second would be the imperative of the state government only, wherein they fulfill the vacancies which are present in the information commissions.
Hmm. Fine.
And so
So,
third,
hmm. So should NGOs be included under Section 2H of the RTI Act?
sir, if a substantial funding is being provided to the NGOs, I think that they can qualify to be included under the RTI. Because sir, it ultimately deals with, like, if a substantial funding is provided, then it would be ultimately dealing with the public money. as well as under. Sir, sir, am I audible?
Yes, you're audible.
Sir, I think there was some issue from my side.
Okay, no worries. Please carry on.
Yes, sir. So, sir, should I start it from the beginning?
No, you can carry on wherever you left.
Yes, sir. And sir, second being the administrative aspects of the NGOs that can be made more transparent. That is from where the funding is being coming and from where it is being utilized. So it would be the national interest.
And what about BCCI and political parties? One minute on them also, yeah, 30 seconds on them. Are they qualifying as public authorities under Section 2H of the RTI? Should we include them or exclude them or maintain a status quo?
So although political parties, so they do utilize some of the government resources while the campaigning, such as the Doordarshan TV and other channels. But sir, I think directly bringing them under RTI, it might give an upper hand to the ruling party, wherein they can, so it can go against the idea of democracy itself. So sir, even if we bring it.
नो सो सीआईसी ने 2013 में एक वर्डिक्ट दिया था पॉलिटिकल पार्टीज के लिए और उस टाइम के 2013-14 के चीफ इलेक्शन कमिश्नर ने क्लियर बोला हुआ है कि पीपीज या पॉलिटिकल पार्टीज शुड कम अंडर दी आरटीआई एक्ट एज पब्लिक अथॉरिटीज। और 2H में आने से क्या होता है, जब कोई किसी बॉडी को पब्लिक अथॉरिटी में डिक्लेयर कर देता हूं, चाहे वो एनजीओ है, चाहे बीसीसीआई है, चाहे वो पॉलिटिकल पार्टी है, उनको एक ऑब्लिगेशन हो जाती है कि सुओ मोटो डिस्क्लोजर उनको कहाँ करना है, अपनी वेबसाइट पे सारे फंड्स का करना है, बिना आरटीआई मांगे उनको अपने फंड्स की ट्रांसपेरेंट रिपोर्ट्स देनी है, फिर उनको इनकम टैक्स रिटर्न्स फाइल करनी है। तो मतलब बहुत सारे ट्रांसपेरेंसी नॉर्म्स उन लोगों के लिए आ जाते हैं। ठीक है?
Yes, sir.
Okay. Are you aware of the differences between ICC and ICJ? ICC, ICJ and Permanent Court of Arbitration, PCA, when it comes to
Yes.
international law?
So ICJ is an UN body, so which deals with the cases between the states rather than the individuals. And so it has two types of jurisdiction, that is advisory and the contentious. So wherein ICC is an international criminal court, so which deals with the cases against the individuals. So, and so it enlists various crimes such as the war crime, genocide, crime against humanity, and the aggression.
Then why do we need PCA?
So PCA provides an alternate dispute resolution, that is the arbitration. So because in ICC, in ICC and ICJ, so that is mainly a court-based proceedings. And so in arbitration, it would be based on the award of an arbitrator. So wherein both the parties can appoint arbitrator from their side and a neutral arbitrator would be provided. So it is seen as a more democratic process.
What is right to be forgotten?
So I think it is related to our digital data, which is being present with the data fiduciaries. And so once the intended purpose is over, so that data should be removed from that particular website.
And how is it different from right to privacy?
So it can be considered as one of the facet of right to privacy. So in privacy, the data is present there, but that should be used in a manner that does not infringes someone.
So I'll give you a one-liner. Right to be forgotten is used for the data on the public domain, and right to privacy is for the data which is not in the public domain.
Okay, sir.
तो सोच कर देखना, बहुत सिंपल है. Okay. Does India respect the spirit of Oslo Accords?
So the Oslo Accords was between Israel and the PLO, wherein they both have agreed to recognize each other. And so India also supports this particular idea that a two-state solution should be the way forward in this particular issue.
Fine. Perfect. Perfect. So, do the new laws, which have, just reformed the criminal justice system, do these laws have a provision for the prisoner under trials and their automatic bail, such as the
Uh,
section 436 in the previous regime?
yes, sir. There is one section wherein if an under trial has completed half of its maximum punishment,
Hmm.
it can be removed. It can be released on bail. And sir, there is one another provision. So with respect to completion of one third of the
Hmm.
maximum prescribed punishment,
Hmm.
so that can be released on bond, I believe. So I
Hmm.
think I got confused, but something on similar lines. One provision is there.
आइए चलो इनको स्पेसिफिकली याद रखना, बिकॉज प्रिजनर्स अंडर ट्रायल बहुत बर्निंग टॉपिक है, और 436 का बहुत आलोचना हुआ करता था कि मिसयूज हुआ करता था। मुझे कमी तुम्हारे आंसर्स में कहीं भी नहीं लग रही, ट्रस्ट मी, मैं झूठ नहीं बोल रहा। मुझे तुम्हारे आंसर्स में 1% भी कहीं भी कमी नहीं लग रही। 1% तो हो, अगर 1% भी हो तो मैं बोल दूं कि तुम्हें नहीं आता।